Hi everyone, we are muted at this time and we are live streaming. Can the clerk please? participated in high school.
Please be seated. Good morning. This is S-1-SC-39739. In the matter of Collins, can I have entries of appearance, please?
Neil Hedrick and Judge Henry, all of you on behalf of the board, University of Rochester.
Thank you. All right, Ms. Pedrick, it appears that you have reserved 15 minutes for your presentation in chief and 5 minutes for rebuttal. Is that correct? Great. Go ahead.
May it please the court. Good morning, Chief Justice and Justices. With regard to Mr. Collins and the motion that we filed for conditional admission, what I plan to do is tell the court what the issues were that the board identified, and then specifically address them as they relate to Mr. Collins, and finally conclude with the weight and how the board viewed the conduct in making the conclusion that they did to recommend a conditional admission to this court. There were 4 basic issues that Mr. Collins presented with, all within 15103. Those were unlawful conduct, conduct that evidence a current drug or alcohol dependence that may impair the ability to practice law, acts involving dishonesty, fraud, deceit, or misrepresentation, and to a lesser extent, neglect of financial responsibilities. The specific issues, though, that relate to those factors would be, and I'll just chronologically go through them. At 16 years of age, which would have been in 2005, Mr. Collins was in high school and going to observe a fight that was off campus. The APS police arrived and found a BB gun, knife, baseball bat, and fireworks in a friend's car. He was charged with possession of those objects as well. He also had a bottle of vodka. He admitted that that was his. Ultimately, this juvenile case was dismissed. We don't have a lot of records, and Mr. Collins did make a diligent effort to try to locate those records, but they weren't available because they were juvenile records and based on his current age. The next year, when he was 17, he had a fake ID, bought alcohol at the Isotopes Park. The same officer that was actually involved in the other incident was there, saw him, and knew that he was underage, got deeply involved, and he was charged with minor possession of fake ID, contributing to delinquency of a minor. And again, those charges were ultimately dismissed, and we don't have records on them other than the fact that he did disclose them to us. More importantly, or really the adult behavior that we observed as part of the application. So at 21 years of age, and this would have been in 2010, Mr. Collins was tailgating what was ultimately an undercover police officer. He was pulled over and marijuana was found in his back seat. The charges were dismissed with the exception of the following 2 closely criminal charge. Then at 29 years of age, and this is really where the board started focusing, I think, a lot of their interest. This would have been in 2018. Mr. Collins had just started law school, and he was charged with another speeding charge for possession of marijuana and paraphernalia, the paraphernalia being a marijuana pipe. The specific date of that was August 29th, 2018. On August 15th of 2018, for about 2 weeks before, he had just gone through the 1L presentation on the importance of disclosure. And as part of that, he signed a document promising to the law school that he would disclose any issues. Now, we know that at that point, he didn't disclose the incidents that had occurred when he was a juvenile, and then he did not disclose this incident that occurred a couple weeks after orientation. The following year, this would have been right when he was beginning his 2nd year of law school, he was charged with negligent use of a deadly weapon. When he discharged the firearm, he was in his home. Somebody was breaking into his home, apparently had done it twice, and APD had not yet responded. He admits that he was very intoxicated and he became belligerent with officers. They charged him with negligent use of a deadly weapon. It was pled to a disorderly conduct charge. So, in looking at all of this, the financial responsibility issues, I would at least advise the
question about the
absolutely, yes.
So is there an ongoing obligation to disclose? Is that what this law school provides?
Yes.
Okay, so he had an obligation to disclose that second one.
Yes, absolutely.
Is that correct?
That's correct.
Okay. And are you aware, we see this on occasion, quite frankly, it's usually not disclosing prior to the occasion. is there anything from the dean of the law school or any communication from law school about what they would have done with that information?
Yes.
Curious whether, for example, it would have impacted the admission to the law school or continuation of service at the law school.
Yes. So I can tell the court that I had a conversation with Dean Pareja about Mr. Collins, and this is about 2 weeks after I had started in this position. So I did have a conversation with him, though, about this because as part of my review, I realized that this disclosure hadn't happened. Mr. Collins then did disclose to the law school post-graduation, and there is a process by which the law school could invalidate his degree. I haven't personally ever seen that done, but that doesn't mean that it's not possible, and they couldn't have done that with him. They did review it, they looked at it, they allowed him to update his application with them and amend it and disclose the items that should have been disclosed without invalidating his degree, which is something that they could have done. So they allowed the amendment post-graduation. So with regard to the financial responsibility issues, and I'll just mention them just so the court is aware, there were 3. One was a medical debt that was in dispute with the insurance company that was resolved and does appear to be an error. One was a car loan that wasn't being paid because of an automatic payment issue. That car loan was paid in full. And then there was a gym membership that was in collections that, again, looks to be an error. I don't think that the court is necessarily concerned about those, and the board really wasn't. Really, it was these incidents that happened as an adult and the non-disclosure. Those were the big issues. So procedurally, though, I think it's important for the court to know how the board dealt with it. So Mr. Collins was a bar examiner. That's how he came to us. He's not a UB score transfer or reciprocity. He was a UNM graduate, as the court is aware. He applied in April of 2021. He was successful on the July 2021 bar exam, so he passed that exam on his first attempt. The board then asked that he be assessed by New Mexico Lab in February of 2022. We didn't realize until April that he didn't disclose. And that's why normally we would catch a disclosure before anything else and have them doing that right on the front end. But we didn't realize until April that he had not disclosed these items to the law school. We asked him to disclose them to the law school, and he did do that, and they accepted his amendment.
How did you discover that he had not disclosed to the law school?
Law school certification form. So that document, we look in conjunction with the application and the criminal history and make sure that they match up, and they didn't match.
Thank you.
So I'm clear, you informed the law school he had not disclosed, or they found that out individually?
We informed him that he didn't disclose and told him he needed to contact the law school and make right with them, basically.
So did he disclose to the Board of Bar Examiners?
Did. He was candid in his disclosures to us. There were no non-disclosures to the Board of Bar Examiners. The only non-disclosure was to the law school.
Thank you.
But even after that, so the court is clear, the board wasn't comfortable even at that moment, though, just offering a conditional admission. And so because of that, they actually set it for a hearing. And he went to a full hearing. There isn't a transcript attached to the motion because oftentimes if we're going to do a conditional admission, we'll include all the exhibits but not do the full transcript because it's a cost to the applicant. It's usually about $1,000. And so we didn't have the transcript made and went ahead and prepared the conditional admission, and that's what's before the court. But there was a full hearing that was conducted, and the hearing panel decided immediately after the hearing that they wanted to offer the conditional admission, and then it went to a board vote, and the entire board voted on it during their December of 2022 board meeting. So with regard to just the factors that that the board considered, the 15103C4 subsection has a variety of factors. The ones that are really specific to this applicant would be 15103C4A, which is the age of the applicant when the issues arise. As I've already recited, a lot of these were happening when he was a minor, when he was 16, 17, and then 21 years old. And the law student era of issues, those are really the ones that the board was focusing on. The recency of the conduct, which is 15103C4B, Mr. Collins has not had any issues since 2019. 2019 was that last criminal incident, and it's important for the court to be aware that on January 26th of 2019, which was about 5 months after this incident with the negligent use of the deadly weapon, Mr. Collins was diagnosed with epilepsy. He had a seizure. he was immediately diagnosed and put on a medication that requires him to consume 0 alcohol. If he consumes alcohol, he's going to land himself in the hospital, if not worse. And so from as far as what we know, he's been sober since then. He has not consumed alcohol, and he has indicated that he does not plan on ever consuming alcohol again. The board also looked at 15103C4E. I expect that that Mr. Cheney will probably give the court more information on this, but Mr. Collins, 15103C4E are the factors underlying the conduct. Mr. Collins had advised the board, both in the interview and in the hearing, that he had some specific losses in his family, specifically a stepfather who raised him, 2 grandparents, and then ultimately a best friend, all within a very short period of time. And that impacted him pretty dramatically and resulted in some of his substance use issues. 15103C4G, which is evidence of rehabilitation, the board absolutely considered. Mr. Collins has sought help for his alcohol issues. He recognizes that he cannot consume alcohol and that they have been an issue for him. He did on his own meet with a law professor that was involved in the New Mexico LAP community and discussed his issues with him. He also appears to be embracing sobriety and his potential involvement with New Mexico LAP, not necessarily as a condition of his conditional admission, but just voluntarily being a part of their programs and also voluntarily attending counseling. He also gave us information regarding his own social contributions since the conduct, involving volunteering with the Hermit's Peak Fire. He works with a nonprofit that's called Beads of Courage that assists children that are coping with serious illness. He's worked on his own art collective to work with Albuquerque youth. And then finally, the last factor, which Justice Vargas just asked about, was his candor in the admission process. It's hard to say, well, he was very candid and honest with us, but he wasn't candid with the law school. But at least with regard to just his involvement with the NMBBE, with the Board of Bar Examiners, he did disclose everything. There isn't anything that we found on our own other than the non-disclosure to the law school. And he's been very, with both during the interview and the hearing, the board members that were involved with him found him to be very credible. And so those are essentially how the board looked at the factors. What the board has recommended would be a 3-year conditional admission. New Mexico LAP, the assessment that they did with him, they indicated that 1 year of New Mexico LAP monitoring would be appropriate based on the substance use assessment that was conducted for him. And so because we're recommending more than just a 1-year conditional admission, during the remaining 2 years, the board has recommended that Mr. Collins have an attorney mentor, that person would be having practiced in New Mexico for at least 10 years or more, and that they would submit quarterly reports to the board to give us information as to how he's doing in both his sobriety and also just practice as a new attorney. And that, of course, as part of the conditional admission, that he not consume any alcohol or any non-prescribed drugs. But that is essentially what the recommendation of the board was. And I don't have anything further unless the court has any questions for me.
Thank you.
Thank you.
Good morning.
Morning.
Please, Your Honor. I'm joined today in the gallery by my client, the applicant, Mr. Collins, and his partner, Monica Adams. And I've also invited, and I think I advised the court by pleading, I invited Ms. Pamela Moore, who all of you know, but she heads up the professional development programs for the State Bar, which includes the New Mexico LAP. I thought, as you will soon learn, the court may have questions of her. She was good enough to accompany me up here today. Ms. Pedrick has done an excellent job of telling the court the basic facts. I think it works for me this morning to go back to the interview, because that really is a stepping stone to what I consider to be the 2 big issues before the court, or maybe where the court may have questions. As Ms. Pedrick said, they had the interview, and it was following the interview or during the interview that the Board of Bar Examiners gave what I'll just, maybe not properly, but I'll just call it homework assignments for Mr. Collins, One was they alerted him to the fact that, yes, he had fully disclosed everything on his bar application, but as unfortunately, not Mr. Collins is not the only one, neglected to make those disclosures to the law school. The second homework assignment, if you will, is the board wanted Mr. Collins to get an assessment through the New Mexico lab. And so all those things were done. But as Ms. Pedrick has indicated, the board felt more comfortable. And of course, they are your eyes and ears in this process, and they wanted to have a full hearing. I'll talk a little bit about the hearing, but I believe that the hearing resulted in the board making a recommendation, making a decision not to transcribe the record. We kind of short-circuited the findings and the conclusions and the recommendation. To me, that says something that the Board of Bar Examiners, the character and fitness hearing, was at least impressed. But let me go back to the interview. I have talked with Justice Thompson offline, if you will, or where he made very clear to me, and I can sense from the questions from the court, one of the concerns of this court is why the heck don't these law students make these full disclosures on their application? It is a problem. When I discussed it with Justice Thompson, it wasn't me discussing it with him. It wasn't a topic brought up. He was talking to Ms. Moore and I. He wanted to know what the heck, why is this not happening? I don't have, and this was all shared with the character and fitness, at the character and fitness hearing. I don't have an excuse. Mr. Collins doesn't have an excuse, but let me at least explain. Mr. Collins his application to UNM was close to the deadline. He was traveling back from Colorado, doing the application as a passenger in a car. And he got to the New Mexico application. He had made a couple other applications, and he knew, he perceived that the University of New Mexico Law School application was different than others. And it seemed to require the disclosure of matters in his life that may have been dismissed, even though other applications didn't seem to solicit that. As some of you on the court may know, Mr. Collins' father is a member of this bar. I think Bob is retired now, but applicant Collins called his dad and said, "What do you think?" And I am not passing the blame to Bob Collins, the lawyer. It was certainly not a fair circumstance for him, but they discussed this, and Mr. Collins, the applicant, sensed that this was different. His father thought, they've been dismissed. I think his testimony, the applicant at the hearing, was, I wanted to be admitted. They were dismissed. My dad says, gosh, maybe I don't need to disclose them. They weren't disclosed. Not bad advice from his dad, but not a fair setting for a lawyer to have to pass advice on. But Bob Collins, the applicant, was wrong. It was incorrect. When this came up at the interview, the applicant then went through the process that is available at UNM and petitioned the dean to amend his application.
Wait, we saw an intervening step, right? There's still as I understand, you're at law school, they have an orientation, and they say, by the way, you're now you're sitting in our school, we've admitted you have an ongoing obligation to disclose this.
Exactly.
Did he get the same advice from his father on that?
No, I think, Your Honor, the distinction that was made that was not a correct distinction, or the reliance, again, not an excuse, simply an explanation, is that all those matters have been dismissed. So it's just, I would argue with you, Your Honor, but you win on this one. It's just, Mr. Collins is stuck with his decision. It was a wrong decision. He went through the process of that does exist at the law school. and Dean Perea allowed him to amend his application. But this is because I know from our conversations, this is important to this court. So I would like to give you a better explanation, but that's what it is. So there's that issue. The second issue is the concern of the Board of Bar Examiners that regarding his use of alcohol. Ms. Pedrick has alerted you to the fact that, and we went through this at his hearing, a long dissertation of Mr. Collins' life. He grew up with a loving family, doesn't have those kind of excuses. His father, Mr. Collins, and his mother were not married. They had Rob. They separated. Mr. Collins, the applicant, his mother remarried. He had a loving father. The applicant had, in many ways, two loving fathers who were very close to him. One of them, well, I know Bob Collins, but ironically, I also was in college with his stepfather. In the period leading to his decision to go to law school, a number of tragedies did happen in his family. His stepfather suffered a severe stroke and died tragically. His grandmother, who was very important in his life because of the nature of his family structure, passed away. Not long after that, his grandfather, the husband of the grandmother, had been diagnosed with early dementia, and he took his own life. Probably two of the things that I've seen most significant in my client's life were when we discussed that. Mr. Collins was required by the police to go in and clean up the remains of his father, who had taken his life by pistol. That was a dramatic factor for him. Rob was going to school. Drinking became the way he dealt with those problems. He gets into law school. He, with permission of the law school, was working during law school in Colorado at a restaurant, and he would work on the weekends, driving back and forth. Alcohol continued to be the way he dealt with the pressures of life. He got through the first semester of law school marginally. Second semester, in Colorado, in between first and second semester, he suffers a seizure in Colorado. It's not clear what that is. It has since been diagnosed as a general seizure disorder. That was a significant blow to him. In February of 2019, probably most significant, Mr. Collins' closest friend in life since 2 years old, a young man who he had gone to culinary school with, was diagnosed with some type of rare disease, an infection of the heart, and died very quickly. Another moment that when I've discussed it with Mr. Collins is just difficult. He continued to drink, and he was on academic probation at the end of his second semester, going into his second year of law school. And days before part of the academic probation was he was not introduced, but he was required to work with David Stout, Professor David Stout. And here's where I have a twofer today. I get a chance to talk to you about how David Stout saved the guy's life. I get to argue to you or present to you. This court is very interested in the Lawyer's Assistance Program and how it works. David is our guy on the ground at the law school. Everyone knows he's very open about his recovery. Over that summer, they worked together, but days before he started the second semester, the incident with the gun. As quickly as I can, there had been a break-in in his house, or the attempted break-in. Mr. Collins had been drinking way too much. He called the police. The police came. They left. The believed to be the person who was trying to break in came back. Mr. Collins had a gun. He went outside, not any more sober than he was when the police came the second time or the first time. And he shot his gun before the police arrived. And then his conduct with the Albuquerque Police Department was less than stellar. And he was charged with I can't remember exactly what level of crime it was, but it ultimately was pled down as a misdemeanor. That was his, what I call in the world of recovery, his magic line. That's when he went to David Stout and said, I've got to do something. And from that point on, as this was all shared at the hearing, the applicant was either on the honor roll or the dean's list. He has been a great student. I give entire credit to Mr. Collins and Mr. Stout. It's a pleasure for me to be able to tell this court, you all know David Stout, but that's the work he does at the law school. He was a witness at the character and fitness hearing, along with Ms. Stapleton, two other lawyers that spoke on, as to his character and fitness. Ms. Pedrick, pardon me, has told you that Mr. Collins has been way involved in the community, working with art for kids. He is involved with the Castaneda restaurant and hotel in Las Vegas. They, during the fires, were very involved in donating food and making meals available. Every once in a while, I get a client that I'm really kind of proud of, and Mr. Collins is one of those folks. I guess that I knew his father, or know his father as a lawyer when he was a lawyer. The fact that I knew his father pretty well in college, sadly now gone, it feels good to stand before all of you and say, on behalf of those two fathers, that I think this applicant is one who would be a good member of our bar. So I'm happy to respond to any questions the court might have. And if the court has any questions of Ms. Moore, I know that's not ordinary, but you all are never bashful. So if you have anything of her, she is here to share with you her thoughts. If not, I'll sit down. Thank you, Your Honor.
I don't have any further presentation for the court. Just making sure that the court doesn't have any additional questions that I can answer to clarify anything.
All right, thank you for your presentations, counsel. The court will be in recess to conference the matter. We will attempt to come to a resolution today and come back out into open court and announce our decision. If that's not possible, we'll alert Ms. Garcia and send you on your way. But for the meantime, please remain in and around the courtroom. Thank you.
And court, please. Attend the court, please.
Please be seated. Again, counsel, thank you for your presentations to the court today. The court is of the opinion that based on conduct, certainly kind of post hoc, but conduct of Mr. Collins in more recent time demonstrate who we hope he will be as a lawyer, and the motion for conditional admission will be granted. Mr. Collins, know that this is your one do-over. And I think you know that based on what Ms. Pedrick and Mr. Cheney have presented to the court. So stay on that path. And we commend the work that you've done so far, and we look forward to seeing more of that in the future. And we appreciate the work of the lawyer assistance program as well. As Mr. Cheney pointed out, the court is very familiar with Ms. Moore's work, and that's what it's there for, is for us to end up in a situation like we're in today rather than the opposite. So thank you for everyone's efforts, and with that, the court will be in recess.
Attend the court, please.